You know, recently there's been so much written and covered in the media about this wrongful death lawsuit in Orlando with regards to a doctor from New York who died after an allergic reaction from food that was mishandled or misprepared on the Disney complex. There was a lawsuit filed against Disney on behalf of the personal representative of the estate. That's the proper way to file a wrongful death lawsuit in Florida. You can't file it on behalf of the dead person per se. You have to file it under a proper legal entity, which has an executive level of a personal representative. They choose somebody, but usually it's selected by the estate. And oftentimes it's the surviving spouse or surviving adult child, something like this. So in this case, it was the surviving adult spouse who filed a lawsuit against Disney, and Disney made a choice to try to kick the case out completely, have it dismissed due to an arbitration clause in a Disney Plus agreement. Now, the main takeaway for me in this is that Disney wants to operate in secret. Why do I say this? Well, this is the nursing home, chamber of commerce, phone company, your mobile provider. This is their playbook. When you sign up, they have you agree to resolve all conflicts through arbitration. And what this means is that the cases are handled in the court system. Court systems are public. This is part of our civil justice system. The things are in public so that we can learn about them, specifically the media. So if the media finds something newsworthy, they can write about it, informing the public. As many of you remember, many years ago, a child was literally eaten by an alligator on Disney property. And the only reason we knew that is because the media picked up on the story and wrote about it. There was an out-of-court settlement in that case before a lawsuit was ever filed. We would have never known about it. And as consumers and as neighbors to Disney, we like to know that. But the second part to that is that inherently, Disney does not trust the citizens of Orlando and Orange County to sit in judgment and a jury in a matter of negligence against them. Apparently, Disney believes that other businesses in Orange County and in Orlando should be sued in court just like any other business, but not them. They're special. So you should think about that the next time an issue is before you involving Disney, is that they felt that they're special enough not to have their cases looked at by a jury in Florida. And also as a customer, you should think about that too. What you think you know about the risks related traveling to Orlando, going to the Disney parks, or any of these theme parks. Do you really know everything? Likely not, okay? And that's the case with really any park. There's always things that we don't know about that were resolved out of court. That's the beauty of our court system, that they're public and our media has access to them. Now, if you look at the legal pleadings, I found them really interesting. There were a lot of legal issues that didn't get addressed because there wasn't a hearing in the matter and the judge never had an opportunity to look at it. The few legal issues that I found really interesting, one is that they relied upon a free Disney Plus agreement that was like a 1-month contract. Obviously, first thing that jumped out to me is that there's no consideration if it's free. The second thing is that contract, just like a phone agreement that you get with your mobile provider, you don't read the whole thing. Nobody does. Those contracts are called contracts of adhesion. In other words, they're adhesive, like they stick to you and you don't even get a chance to read it. Interestingly, in this case, before Disney decided to withdraw their motion, the Disney lawyers argued that it doesn't matter whether or not the plaintiff ever even read the arbitration clause. Think about that. They wanted to bind him to an arbitration clause that they didn't care if he ever even read. One of the things that was not really covered by the media in this case was that Disney had already answered the lawsuit and even conducted discovery on this case before they filed the motion. Why is that important? Well, in Florida, there is a rule that says if you're looking to dismiss something based on some prior agreement and send it to arbitration, in other words, enforce an arbitration clause, you should be doing that before you answer the complaint, but definitely before you start doing discovery. So the judge did have an out if those other legal issues didn't work, or the ones I'm about to talk about. It's an untimely motion anyway. Who knows, maybe Disney will try this earlier in another lawsuit. The other part to this that I thought was interesting is that the technical party to the lawsuit was the personal representative of the estate. It wasn't the individual who signed up for Disney Plus. I think there was a way out too, in that it wasn't the proper party that they were trying to latch on that agreement to. And so you look at all these things and you have to ask yourself, what was Disney thinking? What kind of message were they sending the public? For me, they sent a clear message that they want to operate in secret, just like the Chamber of Commerce advises the phone companies and the nursing homes and other businesses that use arbitration contracts. Apparently, the public outcry was so large, they withdrew their motion. And I have to tell you, in all my years of practicing law, I don't know that if I can remember a time when a corporate defendant withdrew a motion without even letting a judge look at it because of the public outcry. So good for everybody for reading those stories. Thank you to the media for following it and all the other lawyers that did videos on this topic. I think it was really important. It was very helpful. It helped our court systems in Florida, and hopefully no other companies will try to do the same. Sometimes you don't need all this legalese to figure this stuff out because there was an issue of a smell test review, right? The idea of using a Disney Plus free membership from like several years ago to apply to a wrongful death lawsuit honestly didn't pass the smell test either. So I think even if a judge was having trouble with the legal issues, I don't know that a judge would sign on to dismissing the case. That is the status of the law in Florida and the things that large corporate defendants can get away with in the counties where they do business. So stay vigilant. Make sure to attend your jury service when you get your notice. And if we can help you in Florida, please give us a call. Thanks so much. Hey, so if you liked this video, or even if you didn't like it and you hated it, leave me some comments, ask me some questions, but like and subscribe, and thank you so much.